Dr. Ashok Ganguly.
Sir, I rise to support the bill. However, my request is that we should not throw out the baby with the bathwater, because there were some very good features in the 2013 bill which has unfortunately lapsed. For example, there was a clause that SEBI can attach bank accounts, property, and arrest a person for his failure to comply with disgorgement orders. Fortunately, you have introduced the clause, the permission of the magistrate or a judge. The reason why SEBI was given this authority, which I thought was draconian, is because the news should not leak out. How we are going to protect the news from leaking out from the network of those who violate the law is something that I think we need to think about a little more deeply. The 2013 retrospective clause that will allow SEBI to settle non-criminal proceedings by issue consent orders was added, and I hope that that will survive. There is no question about it that the revised amendment bill has certain positive features, and we should compliment the government for that. One of the features was in the 2014 bill, which has been brought to this House, is to authorize SEBI to enhance penalties imposed by an adjudicating officer while also prescribing minimum levels of penalties for these offenses. I think that is the flexibility well defined. However, one of the questions that came to my mind going through the bill, that given the organization of SEBI, does it have enough resources to carry out the enormous task that you're handing over to them? This is something that you might wish to look into, because we have a lot of good laws, but the problem is that we fail to implement them. For example, the bank's campaign against habitual defaulters has really not made any progress. And recently, a bank chairman or CEO was detained for things which might be more widespread than we are aware of. Why aren't willful defaulters being dealt with far more stringently, heavily, and with a sense of immediacy? Which reminds me, and a lot of people have spoken about the Ponzi scheme. It's an American word from Mr. Ponzi. But the point of the fact is, it is the Punji, anti-Punji scheme. We call it Punji, savings. तो पिंजी का विरोध में जो होता है, वो ही हमारा देश में widespread, that is completely under the radar screen, और गरीबों का गरीब सब ले जाते. On the other hand, the Ponzi schemes are being used to launder black money. That is a major use of the Ponzi scheme. You will recall that truckloads of depositors' receipts were sent to the SEBI for them to investigate who were the depositor to whom the money was returned by a certain company which I do not wish to raise the name of. Therefore, I think the worry that I have is the SEBI's public pronouncements sometimes border upon an overreach. And I would say that there must be some safeguards also, that this holier than thou and holier than all attitude may not start from one end of the pendulum swinging to the other end. This is a worry that I share with the House, and I hope through you, Chairman, the Honorable Minister will kindly make a note of it, because all the pronouncements of SEBI are more worrying than the reality of what is done. Therefore, the Chairman having run the bill, and I have never exceeded the time, I still have got 1 minute, Mr. Chairman.
4 minutes. 4 minutes.
Oh, it's over. So, as an usual discipline,
Only 4 minutes
House,
is allotted.
I will leave my speech incomplete. But I think the Madam
We are
Minister,
running short of time. And
उनको पता है मैंने क्या बोलना था, क्या हम छोड़ दिया. Thank you. नमस्कार.
धन्यवाद.